Good morning. Welcome to the second in our series of webinars on how not to lose an employment tribunal. I'm joined today by my partner, Will Walsh. We'll be following on from the last session, which looked at protected conversations and how to try and avoid tribunal claims. And we'll be looking at, first of all, early conciliation. Will's going to go through the process in relation to that and how we might use it to our best advantage. And then I'll be looking at the early stages of an employment tribunal case, how we respond to it and how we begin to prepare our case and the evidence and the important things to keep in mind there. Before we get going, there's a couple of pieces of housekeeping. There should on your screen be two buttons, one chat button and a Q&A button. Could you use the chat button if you've got any technical difficulties, if you can't hear us or what have you? If you've got any questions that you want to ask us, can you use the Q&A button? And they'll be fed through to us, and hopefully we'll get some time at the end of the session to go through those questions. By way of follow-up, after the webinar today, we'll be sending you a link to the recording, to the slides, and to the full Q&A document. So I'm going to ask Will to start off by looking at early conciliation.
Many thanks, Simon, and good morning, everyone. So we're going to start off this one with a quick poll for you. So the question is have you ever settled a claim via the ACAS early conciliation process? And by that, I don't just mean via ACAS full stop. I mean specifically in terms of the particular process that runs immediately before a tribunal claim is filed by a claimant. So during that early conciliation process, how many have settled a claim in that way? So we'll just take a few moments to gather responses in. Then while we're waiting, so it'll be interesting to see what the results are. I think from my own perspective, certainly, I don't see all that many. Possible that we get a slightly distorted view of things because we tend to get notified when the claim actually arrives rather than necessarily by our clients during early conciliation. But actually, that's quite interesting. To say realistically, say from our perspective, we probably see maybe 10% of claims get resolved during that particular initial period. And up to the stats we've got through, we've got 43%. So we're getting close to half of you have actually used that early conciliation process to settle a claim, which is quite interesting, because I think it is generally been quite underused by people. And obviously the purpose of this particular session is to take a closer look, and perhaps some of you who haven't thought about using it before might change their minds. So in terms of a very general overview of what it is, many of you may be familiar with it, particularly those who have used it, but for those who want a refresher or haven't come across it before. Basically, early conciliation, first point is it's mandatory first step for almost all tribunal claims. So there's a few limited exceptions. They're so limited, I'm not going to even trouble you with going through those. But for the vast majority of tribunal claims, a claimant will not be allowed to submit their claim to a tribunal unless they've been to ACAS first and been through the early conciliation process. So that's the first point. What happens then is once the claimant gets in touch with ACAS to start the process off, it freezes their tribunal time limit. So for most tribunal claims, there's a 3-month time limit from their dismissal, the incident they are complaining about. There's normally a 3-month time limit to start things off. And basically what happens is that the early conciliation process freezes that time limit. So it stops the clock while the parties see if there's a chance of resolving it at an early stage. ACAS, for those of you who are not familiar with them, they are an independent conciliation body. They assist with all sorts of different types of disputes. In this context, it's employment tribunal disputes, and they will assist as best they can to try to resolve the matter. The process at the moment under current law continues up to a month, but there is scope to extend that by a further 14 days. So basically, if there are decent negotiations underway and both sides agree with ACAS that it's worth persevering with the process to try to get the deal over the line, ACAS can agree to extend it by 14 days. However, everything's changing on 1st of December, so new regulations are now in place that come into force on 1st of December, which are going to change that period to a flat 6-week period rather than 1 month and no extension. So that's happening from 1st of December onwards. And then effectively what happens at the end of it is if the matter is resolved, then great, and we'll look at that in a bit more detail in just a second. But if not fully resolved, then the tribunal time limit, so the clock gets unfrozen, the tribunal time limit starts ticking again. The claimant will always have at least an extra month, which basically means in practice that if early conciliation process is started in the final few weeks, on certainly the final month before the normal time limit, they'll get an additional extra month once the clock starts ticking. So actually it can draw things out by a fair amount. So if a claimant has got a 3-month time limit normally, they might get in touch with ACAS with 1 day to go. So they've almost had their full 3 months. You then conciliate for 6 weeks, doesn't reach the desired result. The claimant's then got another month after that. So actually from the original incident, we're talking about 5.5 months further down the line before the claim could proceed to the tribunal potentially. How does the process work? In very brief summary, first of all, the claimant has to get in touch with ACAS. They can fill out a form online, they can do it by post, or they can phone up ACAS and run through basic details. They give no detail at this stage about the nature of their complaint. All they do at this point is they basically say, I wish to start early conciliation. They give their name and address, and they give your name and address. And that's pretty much the full scope of what they need to give at that point. And that starts the process off. Once that happens, ACAS then pass the matter to a conciliator, and they get in touch with the claimant, or at least try to get in contact with the claimant and ask the claimant the question of whether they are interested in the prospect of conciliation. If the claimant says no, that's the end of the process there and then. So ACAS will move on to wrap up and conclude the early conciliation process at that point. Same applies if ACAS can't get hold of the claimant after making reasonable attempts, that happens as well. But assuming the claimant says yes, that they're interested in principle, then the same happens in reverse. The ACAS then gets in touch with you, the respondent, and asks the same question to you. Are you interested in the possibility of entering into conciliation to try to resolve the dispute? And again, same options. If you say no, not interested, that ends the process. If you are interested, then then it carries on. The 6-week conciliation period has already started to run by this point. So that runs from the moment the claimant gets in touch with ACAS for the first time, rather than from the point that both sides have said they're interested. So bear that in mind. If you're thinking about using it, giving ACAS a prompt response is always a good idea. Other point to bear in mind is that if you think a tribunal claim might be in the pipeline, it might be that you have a number of messy redundancies, for example, and you think that there's a decent chance that claims may follow, possibly they might be commercially sensitive. There is a potential concern that ACAS might contact the wrong person. Because when the claimant fills out the initial form, there isn't actually any space in the form to give the names of give a named individual. They just give the name of the organisation, the address of the organisation, and a general phone number. If you're worried about that, there's an easy fix. ACAS have got a database of employers and the main contacts for the purposes of ACAS conciliation. They run an automatic database for large employers, and generally speaking, that means employers with 1,000+ employees. But it's not exclusive to them, and you are allowed to put yourself on the database. I've got the email address there on the slide there, so eccontactslist@acas.org.uk. So any employer can email ACAS via that email address and ask to be added to the database and give contact details of your head of HR or whoever it might be that you want ACAS to contact in the event that you have to go through this process. So that's worth thinking about. As I say, what happens at that point after onwards is there is a conciliation period. We'll look at that in a bit more detail in a second. And then the final piece in the jigsaw of the process is that if the issues are not fully resolved, then ACAS issues what we call an EC, an Early Conciliation Certificate, and the claimant needs that certificate number to proceed with a tribunal claim. So if we move on one more slide, again, question to you in terms of, we're going to look at sort of how effective we think it is. So question is, what percentage of tribunal claims do you think gets settled by ACAS? So from the point that someone gets in touch with ACAS to start early conciliation to the very end, what do we think? How effective do we think ACAS is? I mean, those of you who've been through it might have some idea, but just for the rest of you, take a guess as to sort of how many claims you think get settled via ACAS. So the results just coming up. So we've got, yeah, a relatively even spread. We've got the majority, 41%, are going for the 25 to 40% bracket. Another 30% have gone lower than that. So we've got 70-odd% of you are going 40% or less. So actually, if we look at the actual stats, so if we move on to the next slide, it's actually quite interesting. These stats relate to the 2018 year. Simply, it's slightly historic, but there's a good reason for that. Simply because claims that started in 2019 haven't necessarily yet got all the way to the tribunal final hearing stage yet. So those stats are slightly less meaningful. So we're looking at the last full year that would have meant that claims would, if they were going to make it that far, get to tribunal. And what the stats tell us is that, first of all, 73% of early conciliation notifications didn't get as far as the final hearing. So, yeah, which is interesting in itself. So basically only 27% of cases that start out make it to a final hearing. In terms of ACAS early conciliation and ACAS generally, it doesn't tell us a huge amount because claims can drop away for all sorts of reasons. It might be that the claimant withdrew. It might be that the matter got settled outside of ACAS. But actually, second point there, ACAS settled 51% cases. That tells us exactly how many they resolved. So that more than half of all claims that started off with early conciliation did get resolved via ACAS, which tells us that must be doing a half decent job. It is being used, and it is pretty effective if used correctly. So in terms of what the potential benefits are, other than as I mentioned, say the fact that ACAS are clearly doing a decent job on it. Again, from our perspective, one of the sort of key benefits, I think, is the simplicity of resolving a matter that way. For those of you who joined the webinar a couple of weeks ago, when we were looking at trying to resolve matters or settle them before dismissal even takes effect through a protected conversation, more often than not, you would try to conclude that type of process via a formal settlement agreement. The general guidelines around that, in terms of settlement agreements, is that once you present the idea and the settlement agreement to the individual, you should, generally speaking, give them around about 10 days to go away, consider, and take advice. And also the settlement agreement, for those of you who've seen them before, it can be quite a lengthy document. And then the third point with a settlement agreement is it's only a valid waiver of claims if the individual takes independent legal advice on the agreement as well. When you settle something via ACAS, that gets wrapped up normally through ACAS's own version of a settlement agreement, which is called a COP3 agreement. Similar to settlement agreements, it can settle a wide range of claims. So it doesn't just have to be the claim that the claimant is complaining about at the time. It can be broader than that, and if drafted correctly, it can cover not just the existing area of dispute, but it can waive all other claims that exist. It can even waive future claims as well. So that's one thing. It tends to be a more simplistic document. It's not quite, although you can still include various important provisions such as confidentiality, agreed references if you need be. Those sorts of bits and pieces can be added in if you want to, but generally speaking, it's a simpler document. There's no need for independent legal advice, and that's quite an important point. In terms of cost, in particular, if you don't have to pay for the individual to go and take independent legal advice, that can certainly help. The idea being that the ACAS sit there as the independent, neutral body and go-between, so they can give the claimant advice on the agreement and walk them through it and do that bit. So that's basically what the law says, is that a waiver of claims can be either through a valid settlement agreement with independent legal advice or through a COT3 agreement where ACAS is acting. So that's quite an important one. So I've mentioned cost, to say, first of all, in terms of the legal advice and the agreement, but also because the agreement's slightly simpler in nature, generally speaking, it's more cost efficient to get one of those drawn up than it is a full-blown settlement agreement. And then the final point is speed as well. I've touched on that already in terms of the settlement agreement 10-day guidance for putting that into place. There isn't that type of restriction for a COT3 agreement, so it can get resolved as quickly as you like, which also means that you can put deadlines on the claimant through that process. So you could, if you wish to make it quite clear that your particular offer is on the table for a limited period of time and then it'll be withdrawn. So all of those sorts of tactics can be used. So it's quicker that way. It's also a quicker way to resolve it as well, and particularly right now where it takes a little bit longer to get things signed off, having to do things remotely. If you are working remotely, if your directors are working remotely, if the individual is also working remotely, it can take a bit of time to go around the houses and get everyone's signature on a document, doing it remotely or electronically. With ACAS, once both sides have confirmed verbally to ACAS that they're happy with the terms, it becomes a binding legal agreement at that point. ACAS will circulate hard copies, but there's a binding agreement in place for both sides. At the moment, the sides that they're happy, so that's something, another advantage. Other couple of things to touch on. The neutrality of ACAS can be really useful in a negotiation. If you're speaking to an individual direct, emotions are running high, it's in the context of a dispute, it can be difficult to get one side or the other to see sense or see the other side's point of view. So again, just having that independent body as the go-between, so the messages or the offers are going via ACAS together with any messages that you want to feed on. It can just be useful in some cases to have that slight buffer in place just to take some of the emotion out of it. And then the final point in terms of the potential benefits is confidentiality. Basic rule is that anything that you say to ACAS is confidential. It is also off the record. So any details that you choose to give or concessions that you might make to ACAS, the claimant can't rely on those in terms of their employment tribunal claim. So even just simple things like if you're discussing the possibility in terms of settlement terms about whether someone might or might not be prepared to give an apology, if it's all open and on the record, you might be pretty reluctant to do that. It's going to be seen as a admission of liability, whereas you could talk about that quite frankly with ACAS without fear or risk of that being fed back or used against you further down the line. So if we can move on, so to my final slide here, again, it's a big question is, should you use the early conciliation process? It's certainly not mandatory. I put down some pointers here in terms of, there will be other factors, of course, but some main things that I think would be really useful for you to go through in your mind in terms of thinking, is this something that we want to embark on, or is it going to be a waste of our time? And I think that a lot of both my clients in the past and employers do dismiss it a little bit too readily, because I think there are some sort of clear benefits if you think these things through carefully. The first point, or first couple of points to think about carefully, is the obvious one is, how strong is your case? and also what is the claim worth. Because the last thing you want to do is dismiss this particular process. You move into the full-blown tribunal defence and all the preparation bits and pieces that Simon's going to talk about in a moment. You do all that work for a claim that isn't worth all that much money, or where ultimately your prospects of winning aren't all that great. If you're in that territory, what is the point of going through all of that when you could, from a commercial point of view, get rid of it at a very early stage, and possibly cheaper than you might do at a later stage. My general experience with claims is that either employers settle them at a very early stage, i.e. during this process or even before this starts. Those that don't, those that wait until the claim's been stuck in, they put their defence in, the preparation starts, it's actually quite rare that claims get settled in the middle. The next touch point, realistically, where we see a huge number of claims getting settled is in the week or so before the tribunal hearing itself, sometimes even on the day of the tribunal. And of course, by that time, you've spent an enormous amount of time getting ready for the case. You've spent a lot of money on it potentially. So again, I think we get plenty of clients who possibly regret it further down the line, the fact they've taken what they see as a strong stance, they decide they want to fight something as a matter of principle, and then lo and behold, when the reality of the tribunal sinks in towards the end, they try and settle it. And again, begs the question, why didn't they go through that process at the start? Also, bear in mind that the title of this series is How Not to Lose an Employment Tribunal. Part of that assessment is, well, what does winning and losing actually look like? It's not just about getting judgment in your favour, because if you go through a claim, let's say you end up spending 100, 200 man hours going through the steps of defending a claim, turning up as a witness, those sorts of things. You've spent 10, 20,000 pounds on a tribunal defence. You win the case, well, but the case was only ever worth, say, £5,000. Is that really a win? It's worth going through that thought process right at the outset, because you could save yourself a lot of time and money if that had analysed properly at the beginning. And that's always something that we can help with as well. Other benefits, you can use the process simply to extract further details. You get the call from ACAS, are you interested in the prospect of early conciliation? If you say yes, you are not committing to having to make an offer even. You're not committing to saying, I am going to settle this come what may. All you're saying is, I'm interested in discussing this further. So it can be used as a tactic to find out a bit more. So that, as I say, you're going to get scant details of the complaint at the outset, but you could use ACAS to say, well, we're thinking about it, but we don't really understand what the claim's about. Can you go back to the claimant and ask them for some more details? That can tease out a bit more information from them. So you might be able to test the claimant's resolve a little bit that way. It also will help you with your assessment of, have we got a problem on our hands here that we hadn't realised before? So it can be used quite well from that perspective. It can also be used to buy more time. If you could sort of think back to the point I made earlier, where potentially start to finish could be 5.5 months with the early conciliation period thrown in, versus a flat 3-month normal time limit for a tribunal claim. A lot of tribunal claims will depend on, the value of them depends on actual financial loss, which in turn will depend on how long the claimant is out of work. So there is potentially a different slant on things. If you're having a discussion with a claimant about possible settlement when their employment has only ended a few weeks ago, versus you get to a point where we're now 3, 4, even 5 months further down the line, you might just get a different picture. It may be that the employee has picked up a new job in the meantime. That affects the value of the claim. That affects the value of the settlement. It also affects their potential resolve to fight the matter further. It may be that they picked up a new job and actually their focus is going to be on the new job rather than ploughing on with litigation for months and months. So again, it can be useful simply to buy yourself more time, just to let the dust settle and see how things pan out. As I mentioned already, again, key consideration, how much time and cost will the case involve? Cost, relatively simple to work out. Again, if you're using legal advice, then normally you will be able to give you a fairly decent estimate of costs in advance. But I think the thing that gets massively underestimated by those who haven't been through a tribunal claim is the amount of their own time that gets involved. It's not just as simple as passing the matter over to your lawyers and then washing your hands of it. It's going to be you and your staff who are going to be the witnesses. It's going to be you producing the documents. It's going to be you turning up at tribunal. It involves an enormous time commitment in most cases, and that's not to be underestimated. Another factor, again, sometimes can be difficult to judge, but you may think about how committed the claimant might seem. In the days of employment tribunal fees, where a claimant had to pay up to £1,200 to proceed with a claim, it was actually quite a common tactic for people to think, well, actually, it's easy enough for someone to get in touch with ACAS. Are they really going to stump up £1,200 and proceed with their claim any further? Let's just wait and see. Nowadays, it doesn't cost anything for someone to stick in a tribunal claim. So I think that shifted quite a lot. But nevertheless, you might still think about, or it might go through your mind, that we don't think that this particular individual is likely to proceed with a formal tribunal claim. They've got in touch with ACAS to try their luck, but we don't think it's going to go any further. If you're in that camp and you're fairly convinced of that, then again, you may feel that it's not worth trying to make an offer. But as I say, I think it's a dangerous game to try to read someone's mind too much. And from general experience, I can't think of many claims at all, actually, where a claimant has started early conciliation and hasn't seen it through to sticking in a tribunal claim. I think in vast majority of cases, you're likely to get a tribunal claim from someone who started the process off. Another factor is, again, some clients can worry about is if we make an offer too soon, does it seem to be too keen? Which can have a couple of potential negative impacts, in terms of one being, from a negotiation point of view, if you stick in an offer, say straight away, yes, we want to resolve this, make an offer right at the outset, might the claimant think that you're worried and then hold you to ransom for a higher amount? Personally, I wouldn't worry about that too much. It's just a straightforward commercial negotiation. You can set your limits around it. You can make it very clear to offer made that the matter is resolved immediately, and if it's to proceed any further, then the offer is going to be withdrawn or reduced. So I wouldn't worry too much about that. Where it potentially might be worth further thought, though, is where if you're concerned of it opening up. In other words, if you had a whole group of employees who went through a tricky redundancy process, for example, first one gets in touch via early conciliation, you might think, well, actually, if we pay out too readily to this person, as much as you might ask for confidentiality in the agreement, the real world is word does tend to get around. Are we then going to risk all the other people in that group jumping on the bandwagon and asking for similar amounts? So that's certainly something to think about. But one word of warning, again, from personal experience on this one, is I think it's dangerous to adopt a blanket approach to that particular question. I would always recommend treating every case on its own merits. The particular client that springs to mind in the past, where for a long period of time, they decided they didn't want any litigation whatsoever. So their policy was, we will settle every single claim. The problem that caused was that everyone got to learn about that. So anyone who left or had the slightest grievance would stick in a claim or threaten a claim, knowing full well that they would get some cash payout. The client then decides to try to deal with that by having a blanket policy of, we won't settle anything, we'll go to tribunal, we'll battle everything. That wasn't great either, because it basically meant that they were committed to fighting claims that there was no commercial benefit in doing so, and they spent an enormous amount of time and resources defending claims. So I say you don't want to have a standard policy for everything. It's a question of assessing individual circumstances at the time. Last couple of things. As a general comment, I think, so generally speaking, people's position tends to harden once a case progresses, so that if you say no to a relatively amicable settlement discussions at the beginning, force someone to stick in a claim, potentially you have to get as far as sticking in your defence and start preparing for the claim. I think, generally speaking, people become more entrenched in their views, say, until potentially they get them getting cold feet just before the tribunal hearing itself. And generally speaking, it tends to drive up the price as well, particularly if the claimant's been spending money on legal costs, then naturally they will be looking for a greater return as the matter progresses, and therefore their price is likely to go up as well. And then the final point is that Simon's going to talk about this in a bit more detail in his section, but there are certain slightly stronger tactics that you can use to put more pressure on a claimant. Those tend to work better if you are contacting the claimant direct or their lawyer direct. With ACAS, because of their neutral position, there is that bit of a buffer. So if you are trying to use a slightly stronger tactic to twist a claimant's arm, potentially that might not work quite so well when you've got ACAS there as the go-between to aid the claimant a little bit from that, talk them through what's reasonable, what's not reasonable, but it possibly doesn't have that same impact when it's reaching the news is reaching the claimant secondhand rather than from you direct. So it very much depends on your preferences, your tactics, and how you want to proceed with the claim. So in a nutshell, I think so those are sort of the main things that you should weigh up when thinking about whether this particular process for you. But say, I think, so generally speaking, from looking at the success rates of ACAS, and indeed that's fed back to our original poll, some of your own experiences, I certainly think it's well worth a look, and certainly don't dismiss it out of hand before you move on with the case. So moving on, so first point, so Simon, have we had any questions in during that first particular slot?
Yeah, there's a couple of questions, Will. One is, what about the pre-hearing hearing? We've had cases thrown out there. Can you settle at that point? And then there's another one, which is, can you deal direct with the claimant?
Okay, so a couple of questions there. The first one, quite simple. The bottom line is you can settle a case at any point. So just because you get through the early conciliation 6 weeks, it doesn't mean that your settlement opportunity is gone forever. You can settle at any point, and you can do that directly with the claimant, or you can do it with ACAS. ACAS will be available right up to the day of the hearing itself. So yes, it may be that you receive a claim, you think there's various elements of it that have got no merit whatsoever. Actually, during the early conciliation process, it may well be worth a chat with ACAS about that. It might just be that the ACAS officer will have that conversation and go through the claims with the claims and explain to them from ACAS why the claims aren't that great and may not succeed. So that's worth thinking about. But if you felt that that wasn't working, and you thought that you would rather go to preliminary hearing, see what claims get knocked out and what you've got left afterwards, and then deal with any remainder after that, absolutely you can do that, and you can settle at that stage. You can settle at any point you like. In terms of contacting the claimant direct, you're not banned from doing it. So again, this applies during early conciliation or even after early conciliation. So you could be having conversations with the claimant direct if you thought that was the most effective way of doing it, and then effectively you could get to a point where you've agreed terms in principle with them direct, and then you get in touch with ACAS and say, look, these are the terms we've agreed. Can we have a COT3 agreement and wrap it up through that more effective and efficient way? You can certainly do that. From time to time, you do get the odd ACAS officer who gets a bit precious about that and thinks, well, I've been cut out of the loop, and why you contact me now? But that's very rare and exceptionally rare, I think, during early conciliation. ACAS are there to help, is the bottom line, and it's very rare that they wouldn't get involved at that time. So yes to that one. Only thing I would say is that the only sort of legal rule you need to be aware of is if the claimant has got a legal representative, so if they've instructed a solicitor, you as employer can contact the claimant directly, but solicitors rules that means that we as lawyers are not allowed to contact the claimant directly. In that case, we can only speak to their solicitor. We can only speak to our counterpart. But obviously we can speak to ACAS, we can speak to the claimant directly if they're not legally represented. So that's hopefully answers those questions.
Okay, thanks, Will. That's very helpful indeed. Okay, well, moving on now, we're going to talk about what happens if the claim does arrive. I'll talk a little bit about process and then a little bit about preparation of our defence to the claim and what we should be doing in terms of evidence, etc. So just in terms of an overview of the process, once the claim arrives through the post, you'll have 28 days to file a response, which is known as an ET3 form. And that's a strict time limit. It is possible to obtain an extension to the time limit if there's good reason. But if you miss the time limit and you haven't got an extension, then you may well be prevented as an employer from defending the claim. So it's always important to deal with any response promptly. The form of response, there's a standard tribunal form that needs to be completed. And then in nearly all cases, an additional document, an appendix to that form is prepared, which sets out the detail of the employer's response. So moving to drafting the response, what should go in it? I think probably the first thing to say is that we've got to work out what we're trying to do in relation to an employment tribunal claim. And in essence, we're trying to persuade a third party, the employment tribunal or the judge, to agree with our point of view. And whenever you're trying to encourage somebody else to agree with your point of view, the first essential is that they've got to understand what you're saying. And I think that underpins the entire presentation of a tribunal case by a respondent. It's all about clarity, so that the employment tribunal understands the reasons why you acted in the way that you did and the decisions that you made. And what I often talk about is penny dropping moments, so that the employment tribunal, when they either read or hear your explanation for a decision or what happened, the penny drops with them and they say, okay, I can understand why it was necessary to do that. I can understand why the employer did that. So as I say, the sort of the underlying theme is clarity. The content of the response, well, we've got to respond to the factual allegations that are made by the claimant. So we need to set out what the employer's position is in relation to those factual allegations. Ideally, you want it to be comprehensive so that you're responding to all of the allegations made by the claimant. And very importantly, you don't want to be putting things in your response form in the ET3, which you're later having to correct or acknowledging are wrong, because you're keeping in mind that we want the tribunal to agree with our point of view. If we're chopping and changing what we're saying about an important issue, they're not going to be agreeing with us. In terms of the level of detail, there's got to be enough information in there for the tribunal to understand our case. However, we don't need at this stage to put in all our evidence to support our case. That comes later on. So it's really a statement of the main positions that we take in relation to the allegations and the legal claims that are being brought. Sometimes the claim form can be rambling. They vary hugely. Sometimes a claim form can be 2 lines. Sometimes it can be pages of narrative about what happened to a claimant with very little sort of coherent legal claim within it. In terms of how we respond to that, it's not our job to perfect the claimant's case. I mean, we just need to state our position insofar as we understand the allegations that are being made. How can you help in terms of the preparation of the ET3? I think this is an important stage. The starting point is that we need to gather information about the reasons why decisions were taken. We've got to understand what happened. So it's very helpful if you can come to us with a clear statement of, well, this is what happened, these are the reasons why it happened. And often that will involve going to the decision makers and saying, well, look, you know, why did you decide that? And it might be a question of going to the decision makers and saying, well, look, the claimant is saying this. What did you think of that at the time that you made your decision? So it's that gathering of information. Moving to the next slide. Often we have to consider whether we need to ask for further information from a claimant. And I think that there's a danger in asking for too much information from the claimant about their claim. So we think that the claim form is obscure, that it's not really clear what the allegations are or the legal claim that's being made, or they haven't given detail of the reasonable adjustments that they say should have been made. If we start asking questions and saying, look, can the claimant provide details of the reasonable adjustments that he alleges or she alleges should have been made, we're probably simply aiding them in perfecting their case. And so I think I'm always very wary of asking a claimant to produce further information, because we'll probably end up just badgering them into improving their case. So those sorts of requests are fairly infrequent. Will, just moving to the next slide, Will mentioned when he was talking about early conciliation, whether there is any stronger tactics that an employer can use to try and pressure a claimant into taking a reasonable position. There are processes within the tribunal system, once a claim's been started, for an employer to exert pressure. And the most obvious are for an employer to put in an application to strike out the claim, or to make an application to the tribunal for an order that the claimant pay a deposit as a condition of being allowed to continue with the claim. Now, those are obviously quite attractive propositions if you're defending a claim which you don't think has got any merit. You think, well, why don't we just apply to strike it out? Surely the tribunal will understand. The truth is that tribunals are very reluctant to use these powers. First of all, the benchmark for agreeing to make this sort of order is very high. So there have to be no reasonable prospect of success, or very little prospect of success in the case of a deposit order, for a tribunal to agree to strike out a claim or to make a deposit order. And they're very reluctant to do that, particularly in discrimination cases, without having heard all the evidence first. So there are occasions when those tactics can be used, but very often the risk is that, well, the tribunals may have some sympathy with the employer's position, but out of a sense of justice, it will say, well, we have to hear the evidence, and they'll refuse to make the order. And of course, it's a moderately time-consuming and expensive process to make application to the tribunal for one of these orders. There'll be a hearing at the tribunal, which will probably last half a day, maybe a day. So you can end up spending quite a lot of money and energy trying to strike out a claim or get a deposit order. And the chances of success are reasonably limited. Another way of putting pressure on a claimant is to issue a cost warning. Now, as you probably know, the tribunal is a forum where there's normally no orders for costs. So if you win a case, you won't recover your costs from the other side. If you lose, you won't have to pay the other side's costs. However, if somebody has pursued a case which stood no reasonable prospects of success, and a tribunal takes the view that, well, they should never have carried on pursuing that claim, or if it's against the respondent should never have carried on defending the claim, they can make a costs order. So what we sometimes do, if we're faced with a claim which on the face of it stands no prospect of success, we will send a letter to the claimant saying, well, look, we don't believe that your claim stands any prospects of success. These are the reasons why. If the tribunal, having heard the case, agrees with our analysis, then we will invite the tribunal to make a costs award against you. And it would be inappropriate, unethical to be bullying when sending those letters. But in an appropriate case, it's quite a useful thing to do in order to try to encourage a claimant to come to their senses and understand the reality of the weakness of their claim. So we're about to move on to the preparation of the tribunal evidence and our case. But before we do that, there's a poll, which is how long does it typically take between a claim being submitted to the tribunal and a claim reaching a full hearing? So you've got a variety of options there. So what do people think? Right, just waiting for the responses to come in. Right, okay, well, a lot of people are saying it takes between 9 and 12 months. Most people are saying that it's unlikely to be quick. The answer is that we're increasingly, and for some time, seeing really long delays. It all goes back to the introduction of tribunal fees. That reduced the number of cases, which therefore meant that a lot of judges were made redundant and tribunal buildings shut. And then when fees were abolished, the number of claims increased and there weren't enough judges or tribunal rooms to hear those cases. So we've had long delays for quite a time. I would say that the average is between 12 and 15 months. I have got a case on the 8th of December, which involves the dismissal of somebody in November 2018. So let's guess that that tribunal claim was put in within 3 months of the dismissal, so sometime in January or February 2019. So we are the best part of 2 years down the line. So it just illustrates the sort of delays that that do arise. So yeah, 12 to 15 months, sometimes longer. Right, well, what ought we to be doing? This is a critical phase really in terms of winning or losing the case, gathering the information together to address the allegations. So what I suggest is that you, with our assistance, prepare a table, and that ought to list the factual allegations being made by the claimant, stating what our position is in relation to those allegations, identifying the documentary evidence that exists to support our position, and also identifying who our witnesses are going to be to cover each issue. Now, the benefits of doing that are that if we do it at an early stage, then it reduces the risk that memories will fade and people will forget about these things. If we complete it and there are no gaps, then we're confident that we'll be able to meet the allegations that are being made. If we complete it and there's a shed load of gaps and we don't have the evidence to support our position, or we don't have the witnesses to support our position, we've got a problem. And it's better that we know about that early rather than later. So, you know, it's important that care is taken at this stage. Let's now look at documentary evidence and some of the things that we need to be thinking about here. We've got to make sure that we preserve it. So typically emails, it's surprising how often emails are archived, they're disappeared, systems are cleared, and people find it very hard to track them down. So I would say at this early stage, we ought to be asking the relevant personnel within the organization, okay, can you trawl through your email inbox? Let's see what information there is which might be relevant to this case. Similarly, do the same in relation to correspondence. Often minutes of meetings, notes, or even recordings of meetings can be very important, and surprising how often informal notes such as scribbles in somebody's diary or workbooks can be very helpful in evidencing what was or wasn't said at a particular meeting. So make sure you gather that together very carefully. There's a tale that I'll tell you in relation to the importance of getting hold of the original documents, and this goes back many years. I was for a newsagent. They had dismissed somebody because of cash shortages, and we were in the employment tribunal. The witness was giving evidence and he was going through in front of the tribunal the figures which he was trying to explain to the tribunal, identified the cash deficiencies, and he just could not make sense of the figures. They just wouldn't add up, and the tribunal were getting increasingly frustrated. and my heart was sinking. And we got to lunchtime. We trooped back into the waiting room, pretty downbeat, and the witness had brought along the original documentation. He looked in his briefcase, pulled out the original documentation, all those lists of figures, and he saw that some of the figures were in red. They were debit entries. And so what he was able to, the penny dropped at that point, that those debit entries were negatives. And when he was able to see the original document and the debit entries in red, he was able to get the figures sorted in his head, and he was then able to explain them to the tribunal, and it made the difference to the case. So always useful to keep originals. What about witnesses? Well, first of all, you need to consider who might be the best witnesses. And then you need to go about securing their cooperation. I think it's worth keeping in mind that the position of witnesses can be a difficult one. They may have some level of loyalty towards their colleague. They're in a difficult position. It's not an attractive proposition to be giving evidence. And to some degree, every witness is a hostage to fortune. We never know quite what they might say in response to questions from the tribunal or in cross-examination. So we need to consider carefully who are going to be the best witnesses. Sometimes witnesses will be leaving the organisation for whatever reason, and particularly if we're talking about delays of 2 years, the chances are that people do move on. What can we do? Well, one thing we can do is get a witness statement at an early stage, which means that at least we've got something in writing, and that links into witness orders, which I'll mention to you in a tick. Probably an attractive proposition is to try to get their agreement to cooperate in the giving of evidence at the tribunal. So that might be part of a settlement arrangement. It might be an informal arrangement with them, an agreement that they will cooperate, and that will help us a lot. The last possibility is that we get a witness order. So if we have a witness statement which records their evidence, it's possible to ask the tribunal to make an order compelling them to attend. But you can guess that if you got to the stage of getting a tribunal to compel them to attend, they're not going to be best pleased. So even though we might have a witness statement, they might not be an easy witness to deal with. So in short, the best thing to do is to try to recognise the need to get their cooperation. Right, well, what else can be done at this stage? One important factor, if the case is lost, doesn't happen often, but sometimes it does, is that most compensation relates to loss of earnings, and there will often be a discussion about has the claimant taken reasonable steps to mitigate their loss. And it's important that the employer can put forward evidence about opportunities to mitigate loss. So keep an eye on the job sections, the local paper on the internet, to see what sort of jobs a claimant might reasonably be applying for, because we'll then be able to show those to an employment tribunal and say, well, look, this was the position. When the claimant says that there was no opportunity, there he's clearly not being truthful, because these are all the opportunities that existed at the time. I think another thing that is useful is to tune in to the gossip grapevine and to social media to see what the claimant is doing. It might be that you'll gather information that they have in fact found employment, which they haven't perhaps disclosed to us. You might find out about what their attitude is towards the claim, how strong their resolve is, etc. So it's always worth keeping your ear close to the ground. Think about protecting the organisation too. It is possible that the employee will be going around town talking about the claim, trashing the organisation. And there are things that we can do about that. If you've got an employee who's saying things which are untruthful, slanderous, etc., then we can take steps to get them to quiet them down. Think about what you tell staff about the claim. They may well have heard about it. Who do you want them to hear about the claim from? Should it be you, or should they just be hearing about it through the grapevine themselves? Get your message across to them. And what might that message be? Think about what you want to convey. Will made the point about the risk that employers can be regarded as a little bit of a soft touch. Sometimes if you're going to take a robust line in terms of defending your position, and particularly if you're successful in doing that, it can be worth making quite a lot of noise about it, because then people understand that you're not, as an employer, a soft touch. And then finally, let's look at the impact of COVID-19. It's true to say that the pandemic has increased the existing problem of delay. Tribunals, like all organisations, are under pressure in terms of staff sickness, absences, etc. So the tribunal administration at the moment is they're in trouble. It sometimes takes a long time for claims to be forwarded. I had one which took over 2 months between when it was lodged to when my client received it. Sometimes it's impossible to get through to the tribunal by phone. Frequently you can be waiting weeks for responses to fairly simple but important queries. So it's a struggle at the moment. Some hearings are being held virtually. We've always had hearings dealt with by phone, but increasingly now there are video hearings, including for substantive hearings for the full claim, which brings obviously additional difficulties in terms of evidence giving. The implications of the long delays, well, I think that perhaps it will result in fewer cases being brought. I think that there is the prospect of pursuing a claim is less attractive if you know that it's going to take 1.5 years or 2 years before you get your case into court, before anybody listens to what you as a claimant want to say. So it may mean that there are fewer cases that are presented. But I mentioned that, from the respondent's point of view, if you've got a 15-month wait, all sorts of things can happen, and particularly memories fade, witnesses disappear, documents disappear, and that's why you need to be thinking about some of the things that we've been talking about. So there are challenges for the respondent. I think also, going back to the point about mitigation, it's probably easier for a claimant to say, well, it's very hard to find fresh employment, and I haven't been able to find fresh employment, and probably a little bit more difficult for us to disprove that. So yeah, like everything else, COVID is having its impact. So those are the things that I wanted to talk about. I can see that some questions have come in as I've been talking, and I think we've just got 2 or 3 minutes for Will and I to try and address these. So right. Can the claimant request or compel a witness to attend even if the defendant doesn't wish them to, although they have provided a statement on behalf of the defendant? So we're talking there about a claimant asking the tribunal to issue an order compelling one of the defendant's witnesses, probably a colleague or whatever, to attend the tribunal. Well, yes, the claimant can ask the tribunal to make an order that one of the defendant's employees attend the tribunal. Tribunal will just ask itself, does this person have relevant evidence to give, and are they willing to attend voluntarily? And if they've got relevant evidence to give and they're not willing to attend voluntarily, the tribunal ought to make the order. And then the last one, which I can see is a tricky one, so I'm going to pass it to Will. Are there data protection implications from keeping your ear close to the ground, particularly with reviewing social media accounts? Would you expect monitoring to be included in privacy notices, for example? What do you think, Will?
Okay. I mean, personally, I wouldn't be overly worried about data protection issues. And again, I don't think it would go down particularly well with your staff if you did say in a privacy notice that we may snoop around and look at your social media accounts. But I think so from a data protection issue angle, I suppose 2 things. If someone's posting something on social media, it's available to the wider world. So the fact you can see it in the first place, they have chosen to post it. It's not private. So that's one issue. The second thing is as well is that there's a general get out under data protection laws if you are processing data in order to defend legal action. So if it's for that purpose, that's a legitimate purpose as well for having the information. So again, you don't want to go too far, generally speaking, about snooping around. You have to be a bit careful about snooping around in terms of your employees' social media accounts, really in terms of the purpose. But if it's there in the context of a tribunal claim, trying to find out if someone's got a new job, for example, as Simon mentioned, I can't see too many issues there, to be honest.
Okay, well, I think that our time is virtually up. So we're going to say goodbye, but just a reminder that we've got a third in the series coming up, and that is to talk a little bit about alternative dispute resolution, the possibility of judicial mediation and judicial assessment, which are things which have been around for 5 or 10 years. They are perhaps increasingly being used. So talking about how those sorts of things operate. And also we'll talk about the final days of preparation for the claim, last minute preparation, and what really to expect from the hearing itself. So thank you very much for joining us. I hope you found it useful, and we'll see you soon. Thank you. Bye.